Hello, I'm Roger Citron. I'm a professor at the Touro University Jacob D. Fuchsberg Law Center. This is a Touro Law Review podcast, and today we have a really interesting one because my guest is John Belcaster. We were law school classmates, we're friends, and we'll be talking about John's work in his current position, which is that he is the general counsel of an organization known as MSCHF. And as you'll see, we're going to talk about art, we're going to talk about law, we're going to talk about intellectual property. And John, to get you started, just tell us a little bit about yourself, please, and about MSCHF.
Yeah, thanks, Roger. What a delight this is to join you in a forum such as this, which will help your students maybe understand some of the things we're involved in, kind of specifically, and generally some of the things going on a wider canvas of the First Amendment and intellectual property law. But you're dead right. I'm the general counsel of MSCHF, the inaugural general counsel. MSCHF is an American art collective based in Brooklyn. And maybe this time a year and a half ago, they thought it might be sensible, given the type of boundaries that they are pushing, the envelopes they push, to bring somebody inside the collective who has an ability to provide some guidance with regard to some of the undertakings at the collective. There are 28 of us who make up the collective, and if you were to ask me, what is MSCHF? I would say, Roger, that's an uncharitable question because there is no single answer to that. Which is to say that if you asked all 28 of us what is MSCHF, you're going to get 28 different answers. But I'll take a crack at my answer, and this might be unique to me. We are a venture-backed art collective, which right out of the box might be somewhat of an unusual characterization for an art collective. Venture back, what does that mean? Well, we have some investors behind us. Now, why is that? Well, you can imagine what Andy Warhol back in the 60s and 70s what might have been able to accomplish at his factory if he had some folks behind him right from the get-go. Now, he went on to attain certain spectacular things in the art world, but he didn't have the supercharge of investors behind him, and we did do from the outset. But as a collective, more particularly, what is MSCHF? Well, we're a collective that comments on and critiques our world and its cultures by participating in our world and its cultures. Now, that might sound a little highfalutin, so maybe I could break that apart a little bit. What might that look like, this critique of culture or by way of participating in culture? Well, one of the artworks we did was aimed at the horrors of guns in our culture, and what might we do about that as a collective? Well, what we decided to do was create an artwork which we styled Guns to Swords. And what Guns to Swords was a call for folks to send to us a violent, wickedly violent weapon, a gun, and then we would turn that gun into a less violent weapon, a sword. And so we had a whole bunch of folks send us a whole bunch of guns. And then in our collective, we melted down those guns in our little, refinery and used the metal from those guns to create a less violent weapon, a sword. And one of those swords became quite a fashionable item. It was wielded by Grimes at the Met Gala a couple of years ago. Here's a depiction of that for those who are able to follow us along visually. Another example of how we critique culture by participating in it is depicted with a drop we did last summer called Eat the Rich. What we did is we took the visages of 5 of the world's wealthiest human beings, and we created popsicles out of their heads. Elon Musk, Mark Zuckerberg, Jack Ma, Bill Gates, Jeff Bezos, hired a couple ice cream trucks in New York City and Los Angeles and sold these popsicles for $10 a piece. And that enabled all of us to literally eat the rich. And then what we did is we kind of stood back and watched this conceptual art project unfold. And it was fascinating to see how many folks were of the view that this was a straight up product being produced by Elon Musk or being produced by Jeff Bezos. And of course, these folks would, have the gall to sell a popsicle for $10, right? Because that's what you do when you're a billionaire. You create a $10 popsicle. Some of the artworks we did involved collaborations, authorized collaborations. The musical artist The Weeknd came to us. He was releasing us a new album, and he asked us to help him create an artwork that no one had ever done when they would release an album. So rather than having The Weeknd release his album on vinyl, we helped him create an artwork called Vinyl Blade. And what we did is we took a 12-inch actual steel circular saw, and we etched his album tracks onto the circular saw blade. And then only made 10 of these, and The Weeknd was a little perturbed by that. He said, well, there are 8 billion human beings on the planet. Why only 10? Well, we did 10 because they were very difficult to actually create. But you literally could, take your saw blade Weeknd album, put it on your turntable at 33 RPMs, and it spins round and round. And you can listen to the track. And you could also cut a finger off if you get too close to that turntable.
Can I ask before we go to the Birkenstocks, how did all 10 sell?
Yeah, we put those up for auction. And the opening price was $1,000, and I forget what the high one went for, maybe 28,000 or so. But they all went wickedly quick. As did the Birkenstock sandal, which is another one we did. This was an unauthorized collaboration between Birkenstock and Hermes. We took a $35,000 Birkin bag, sliced that Birkin bag into leather strips, used those leather strips to create a Birkenstock sandal, a Birkin. Birkenstock was delighted by this. Hermes, not so delighted. But we just did 10 of these as a limited art pieces, put these up for auction, and they all disappeared within 5 minutes or so. And the highest price paid for one of these artworks was $76,000. I think Drake, the musical artist, might have been the purchaser of that. We comment on a phenomenon within sneaker culture and pop culture in general, and that's the collaboration. The notion that shoe manufacturers like to collaborate with artists, and car manufacturers like to collaborate with social media influencers. Well, we said to ourselves, well, if we were to create a shoe, who might we want to collaborate with? Well, how about Jesus Christ? So we created the Jesus shoe. And that was a customization of ours, where we took a actual Nike shoe, and we injected the heel of the shoe with holy water and adorned it with some religious regalia. Limited amount of those at a very high price. Those sold out instantly. And then we said to ourselves, well, what's another commentary you can make on collab culture? How about we do collaboration with Satan? And along with Lil Nas X, we again took a Nike base and created the Satan shoe, to the delight of Lil Nas, who was launching a new album, but to the dismay of Nike, who sued us for intellectual property infringement. Interestingly, Nike had no problem with the Jesus shoe, which in some ways is even more blasphemous, I guess, than the Satan shoe, because you're literally walking on Jesus. But they did not look fondly on our Nike customization.
Can you? I don't want to take us out of sequence. What happened with the Nike suit? With the over the Satan shoe.
They raced in on a TRO in the Eastern District of New York, and the judge granted that TRO very quickly. We weren't even permitted the opportunity to file papers. I think from the moment we received the TRO to the moment we had to step up, 2 days had lapsed. TROs enter, judge sets preliminary injunction hearing for 2 weeks hence. So in that 2-week time, we very quickly resolved the matter with Nike. That was 2 years ago almost to the day, and then a year ago to the day, we found ourselves in the crosshairs of another major shoe manufacturer, Vans, when we did a riff on the Vans old school skate shoe. A lot of our approaches to art stem from the modern art sensibility of Marcel Duchamp, all the way through in his use of ready-mades as a product of the source material for his art, and stretching through contemporary art of Ai Weiwei. And so what we do, like Duchamp, like Ai Weiwei, like Andy Warhol, is we look for a cultural icon. And with regard to the wavy baby shoe, it was the Vans old school. And we use that cultural icon as an inspiration of sorts for us. So what we did with Vans old school as a cultural icon is we literally waved it. And what the comment we were making is that this literally is not a skate shoe. This is not a skate shoe. And to make the commentary even clearer, we slapped on the sole of that wavy baby as a parody of legal disclaimers, not a fine print disclaimer, but a very vivid disclaimer that warns the wearer of the shoe that these are extremely wavy. And if you wear these extremely wavy shoe, you might actually fall. As George Bush did back in the day. And if you look at the heel of our wavy baby, you see that it's hard to see.
Oh, this is in the lower right corner?
Yeah, the lower right corner. If you looked at the heel of our wavy baby shoe, it doesn't say Vans because that would be an infringement. Instead, the heel of our wavy baby is a graphical depiction of a cherubic baby falling off a Segway. And that's a tip of the hat to George Bush's interaction with the Segway at his summer home in Kennebunkport, where he had a miserable fall because of his interaction with technology. So part of this is a little bit of political speech here, a little bit of critique on our tech society. Let me stop there, Roger, because I'm going way too deep on what is MSCHF, but that enables us to at least have a little bit of insight as to the type of art we do and how we do it and what we're up to.
Well, stealing from another 1960s reference, you sound like quite a band of merry pranksters. And let's turn to there's this amicus brief that you shared with me recently that MSCHF filed with the Supreme Court in this Jack Daniels whiskey case, and we see you put up an image here that has the what the fundamental principles in the case, what the fundamental conflict is, which is trademark law versus the First Amendment. And this case, I believe it's going to be argued next month or maybe later this month. It's Jack Daniels versus VIP. So now I'm going to ask you to draw on some of the things we did decades ago, which is, as I say in class, tell us a little bit about the case and how you came to be an amicus in the case.
Yeah, sure. Well, we're not going to be able to start understanding Jack Daniels unless we move back in time about 3 or 4 months to another important case, Goldsmith versus Warhol. So why don't we start there? Because there are two big constitutional battles in the Supreme Court right now. One of them pits copyright and constitutional right against the First Amendment, and the other pits trademark, a statutory right, against the constitutional protections afforded by the First Amendment. So with regard to the first front of that battle, copyright versus First Amendment, this is the famous Goldsmith versus Warhol case. Very briefly, Lynn Goldsmith took a photograph of the musical artist Prince in the early 80s. Very briefly, simplifying tremendously, flash forward a couple of decades, and Goldsmith learns that Andy Warhol has, spun his magic on a photographic image of hers without her permission. Lots of procedural complexity in this case. We'll put that aside to get to the core issue. And the core issue that the Supreme Court is grappling with is whether or not the work that Warhol did against the base of the photograph is sufficiently transformative to enable a fair use of the Goldsmith photograph, an unpermissioned fair use of the Goldsmith photograph. And what's interesting about, many interesting things about Goldsmith versus Warhol, but the transformative use doctrine arose 30 or so years ago, the last time that the Supreme Court granted cert on a copyright issue in a creative context. Now, it's not often that the court speaks about copyright. They did it in Google a couple of years ago, and it's even less often that they speak about copyright in a creative context. But they did in 1994 in the famous Campbell versus Acuff case, which involved the musical act Two Live Crew, who was appropriating a Roy Orbison Pretty Woman track and undertaking some transformations to the Orbison track, and the Orbison rights holder took a dim view of that. And it was in the Campbell versus Acuff case that the Supreme Court, in a 9-0 decision, ruled unanimously for the creative, for Two Live Crew, for Luther Campbell, in holding that what that creative did with the Orbison track is of such transformative nature that it is unquestionably fair use. So that's the issue at stake right now in Warhol, because in the 33 decades since, it's been become a bit confusing as to what is transformative and what is not transformative. So that's, constitutional battle number one, First Amendment, intellectual property. And then constitutional battle number two is Jack Daniels versus VIP. In this case, as you noted, Roger, will be argued on March 22nd, about a week and a half from now. And the core issue in this case is one that's been befuddling creatives for about 2 or 3 decades, and that is what can creatives do with a trademark that is permissible under the First Amendment, and more specifically, if a creative like VIP, who created the rubber dog toy, is engaged in expression, number one, is it permissible expression that's being engaged in? And if so, that's a very low bar, by the way. And if so, is that expression explicitly misleading the audience or the consumer market into thinking that that expression is an utterance of Jack Daniels? And that's a very important issue, because over the last 20 or 30 years, the brands, the corporate property right holders, have taken the position that they and they alone own all and possess all downstream rights of commentary about their products. They and they alone have veto rights as to what can and cannot be said or expressed about their products. And maybe most perniciously of all, the brands are of the view that if an expression takes place, in fact, on a canvas really other than a canvas that you would find on a white-walled gallery, that expression enjoys no constitutional protection, which is a ham-headed way of saying that if you were to try to express anything about Jack Daniels on another commercial product, whether it's a dog toy or a shoe or a t-shirt, that medium is an impermissible medium, because that medium is a commercial medium, and because commercial mediums are commercial speech, the brands have every right imaginable, so they say, to police that speech. And sadly, over the last 20 or 30 decades, large swaths of the judiciary has kind of bought into that corporate property right precedence over First Amendment protection argument that the brands have laid out over the last 20 or 30 years.
Yeah. Can I stop you there? Just, obviously there's, the cases are pending, and so we'll hear from the highest court in the land on it. When you think back about, or when you think about the legal landscape that you just described over the last, say, 20, 30 years, why? And I ask that, like, why has the law, at least in some courts with some judges, developed in this fashion? And we're of course in an era where, everyth's political. So of course, that's sometimes the first place we look for an explanation. But let me make it an open-ended rather than a leading question, and just ask, why is that? Why has the law developed in the way that you've described?
Yeah, well, that's a good question. It doesn't take a rocket science to observe that this pendulum has really swung far from First Amendment artistic expression and towards the property rights of the brands. Why is that? Well, at base level, you can attribute just some misunderstanding among the judiciary as to what art is. When we stepped up on a Nike in the Eastern District, one of the things that the judge said from the bench is, well, how can this possibly be art if you're making money off of it? So there's this, at base, there's this, complete misconception that if you're an artist, you have to starve, right? But where is it ever said that in order to be an artist, you must starve? So that's one driver of this pendulum swinging towards the property rights side of the spectrum and away from the creatives and the protections under the First Amendment. Another, this is just one person's opinion, but you can imagine there's this thinking that this type of appropriative art involved in the Prince Warhol, involved in Jack Daniels, is somehow thievery. It's somehow cheating. And again, that's just a misunderstanding as to how art is created and how cultures advance themselves through the free exchange of ideas. And this notion among the judiciary or the trademark bench that creatives are somehow cheaters by appropriating is particularly frustrating, because if you look at the history of the brands themselves, they have openly taken from culture. They have openly borrowed from our iconography, and we make very heavy use of that in our amicus brief. But what happens is once the brands borrow, they want to lift the ladder up behind them. They want to close the barn doors behind them. But then you ask yourself, well, why are they getting such a free pass? Which is the core of your question, Roger. Why are the courts, carrying so much water for the brands? You can be cynical and say, well, I don't know, look at the composition of the judiciary. Are many of them coming out of, corporate legal defense? Do they think the creators are cheaters? They just don't understand the nature of art and how art is created. So a lot of that could go into it, but there's also one other thing that goes into it, and not to be, so holier than thou. Many of us have a sense that the judiciary just really doesn't understand fundamentally how trademark law ought to work. In copyright, the copyright holder has a right on all derivations of the copyright. So if Lynn Goldsmith, she has her Prince photograph, if someone were to draw a mustache on Prince, that's a derivative, and she is the rights owner to that derivation. And you can't engage in that type of derivative without Lynn Goldsmith's permission. There's no similar right of downstream iteration in trademark law. There just isn't. But the trademark bar wishes there were, perhaps, or thinks there is, and is convinced the judiciary perhaps that there is. So that when you do a derivative of a Jack Daniels bottle, and you do that derivative in the form of a rubber dog toy, there are large swaths of the judiciary that thinks that right out of the box is impermissible, because it would be impermissible under copyright for sure. But it's totally permissible under the statutory rights of the Lanham Act. So at root, there could just be a fundamental, elemental misunderstanding of how trademark law actually works.
Really, really interesting, truly. And you alluded to, or you didn't allude, you actually mentioned your amicus brief in the Jack Daniels case. And I think if you feel like you've, sort of set the stage for legally what the issues are that are before the court in that case, can we talk a little bit about your creation, the amicus brief, and how that came about and what you're trying to do with the amicus brief?
Sure, sure. All right, so what launched this art project of ours? Well, principally what launched it is we have our own litigation. Van sued us for our wavy baby, and that worked its way up to the Second Circuit Court of Appeals, right below the United States Supreme Court. And the Second Circuit we briefed our matter on an expedited basis because they're First Amendment issues. We had an oral argument. We were expecting a decision back in November, December. When the court granted certain Jack Daniels, the Second Circuit put our matter on hold. All right, so now we are at the mercy, so to speak, vividly in our litigation with regard to what the Supreme Court does in Jack Daniels, number one. Another reason we fired up this art project of ours, and by way of amicus brief, is because the type of art we do, ready-mades, cultural ready-mades, appropriation art, is going to need at some point clear guidance from the Supreme Court as to whether what we're doing is permissible or impermissible under the Constitution. We need to figure that out. And so to help the court figure that out, we were of the view we have to have a role in what's happening in Jack Daniels. And then there's a third reason that caused us to think about having a voice in the Supreme Court. And this, again, stretches back to Goldsmith versus Warhol. I attended the oral argument in Warhol versus Goldsmith versus Warhol, and things were unfolding before my eyes that were uncanny. One of the first things that I noted was that Clarence Thomas, who many of us know is sometimes a bit reticent and quiet, was right out of the bat engaged in this oral argument in a rather jovial manner. He opens up with a commentary about being a fan of Prince in the 1980s, and Justice Kagan says, "You're not a Prince fan any longer," and Justice Thomas says, "Only on Thursday night." So here's a rather serious-minded justice, like joking, number one, and number two, involved in, as some of your listeners know, Justice Thomas for a decade didn't say a word from the Supreme Court. He was the silent justice. Now he's fully engaged. I'm like, aha, this is a notable moment. But another thing that was unfolding is this rather vivid hand-wringing among the justices as to, what is art? How do we know what's art? And judges aren't equipped to say what's art and what isn't art. And there was this tremendous struggle among the justices. And so you hear that and you say to yourself, is there anything we can do to help the justices understand what art is? And yes, you are equipped to determine what is and isn't art. Then you hear the Jack Daniels lawyer, as I mentioned a few minutes ago, take a position, paraphrasing, that the medium matters and, art can only occur in the fine walls of a gallery. And then I heard Justice Thomas ruminate, well, if I took in a Warhol of yours, Warhol estate, and I put it on a flag and I waved the flag at the Syracuse football stadium, you would sue me for that Warhol estate, wouldn't you? Because that's a non-permissioned use. It's not a fair use. So you put all those observations together as a number three, and I say to myself, wow, we have a real teachable moment here. So we have a need intellectually to have a voice, but we also, as artists, have a mechanism whereby we could teach the court as a friend by having the court do something. And we could teach even more powerfully and effectively by having the court do something together. So we invited the court with our amicus brief to literally do something together with their clerks, do something on a medium that is atypical. What's the atypical medium? What if we turn the pages of an amicus brief into a canvas for art? And then we say to ourselves, justices and clerks, all of us as human beings have the wherewithal to engage in artistic expression. It's not that difficult. And once we engage in artistic expression, we're equipped ourselves and among ourselves to judge whether or not that's art. We don't need experts to help us with that. We can compare our artwork to our clerk's artwork. But by the way, justices, for those of you who are of the view that art can only be something that hangs on a gallery wall, here's an invitation to you. Participate in this artwork, send it back to us, and honest to goodness, on a consignment basis, we will exhibit these artworks at the Perrotin Gallery, and you yourself will be the recipient of the sales price of any one of these artworks. It's really not that complicated. So that's kind of how and why we serve this up to the court.
Yeah, and it's clever, truly. And you know, we were talking a little bit before we started recording about I was an American Studies major, and I really hear a lot of sort of really, at least in my mind, I associate it with how, you know, some of the readings and some of the professors would talk about Warhol, the idea of, right, the connection between democracy and consumerism, like small d, and you know, the effacing or removal sort of you know, if you will, barriers to culture, very truly and very seriously. And yet I have to ask, is that the best way to approach the Supreme Court, to try and, you know, the purpose of a brief is to persuade or influence the court, because well, I'll go with the adjective cheeky. It just sort of seems like, you know, you're inviting them to participate in something with this connect the dot exercise, which I know you're going to show us. I believe there's some subsequent slides coming. And I wonder whether just sort of how you thought through the decision to go this way with the amicus brief. Conceptually, everything you say makes sense. And yet, you know, this is the Supreme Court, right? The same court that decided Marbury and said we're a nation of laws, not men, and you know, all this reverence that we're taught to have for the court and so on. So your thoughts on sort of that particular aspect of the brief and
yeah, no, that's a terrific question, Roger. Because to be quite honest, as we were kind of working through this concept, we were of the view initially that maybe the submission ought just be the call for entry and ought just be the art, connect the dot, and nothing more. But then when we step back, in large measure for all the reasons you just described, that would have been a little too cheeky. Let's not just have this thing speak for itself. That might be too meta. Let's back it up with what the court is accustomed to working with, a whole bunch of text and case analysis and precedent and what have you. So in that regard, we wanted to be respectful to the process. But I got to say, we were leaning into the cheekiness, and we felt comfortable doing that for a couple of reasons, not the least of which was the observations gained at the Warhol oral argument. There was something about art that was creating a delight among the justices. And that's what art does. It could cause us to wonder. It could cause us to question. It could cause us to surmise. It could cause us to ruminate. And so we thought, because art has the ability to reach deeply into who we are, why wouldn't we play to that cheekiness, or use a vehicle that could be construed or described as being cheeky? And then once we were comfortable with that, let's do it in a way that that could generate some delight, that has a more than a dollop of humor attached to it. So yeah, you're right. It is a little trepidatious, given its unorthodoxy. But at root, we're all human beings, and there was something about the discussion and interaction with art at Warhol that said, "Aha, we might have a way of just kind of getting into the justices, not just their minds, but into their hearts."
With I maybe have one or two questions left, but before we get to those, knowing because you previewed your slides with us, can you walk us through the brief? And I know that right, each, I believe, right, not just the justices but the clerks were given an image or a page where they could do art, and I'd love to know sort of for at least some of the justices, say, or even some of the law clerks, how you arrived at what the image would be that they could create.
Yeah, so a couple ways to come at that. We decided to invite the justices and their clerks, all of them, not just the justices, because of the view that that's a broader spectrum of doing something together. Number one. Number two, at the margin, I guess you can make the argument that 45 versus 9 participants increases the probability that we might get one of these back. I really wish many of us really wish, not just in the collective, but outside the collective, that Justices Breyer and Ruth Bader Ginsburg were still on the court, because there's a part of us that says they might be more inclined than anybody to take up the exercise and actually move it all the way through. But be that as it may, we were mindful about how these assignments went out. And what we were trying to do was to serve up imagery to any particular justice or clerk that would be imagery for which that justice or clerk had a certain affinity. Because you look at Jonathan Haidt, social psychologist. He's got this great book out there called The Righteous Mind: Why Good People Argue About Politics and Religion, what have you. And the conclusion of Jonathan Haidt's research is you're never going to. This is somewhat self-evident. You're never going to win somebody over by characterizing that person as foolish or an idiot or a jerk, right? You're gonna win somebody over by kind of standing next to them and helping them understand that there's a commonality. So we wanted to draw upon commonalities that any of these clerks or justices might have with what we're putting in front of them. So we did some research. And it was a bit easier with the justices than with the clerks, as to some of the interests of the justices and the clerks, some of their backgrounds. And what you come up with is for Ketanji Brown Jackson, we learned that she, in her high school yearbook, was holding in her arms a Winnie the Pooh stuffed animal. And so we thought, well, if we serve up something to do with Winnie the Pooh that could draw upon a happy memory of hers, being a theater enthusiast in her high school. Justice Thomas did this rumination about the musical artist Prince and the Andy Warhol and the orange man as the mascot of Syracuse. So we served that up to Justice Thomas. Justice Alito was in the military. So if you look at Justice Alito, his connect the dot is called Back in Black. I don't have it at the finger.
Okay. I was wondering if, yeah.
It's NATO instead of AC/DC. Neil Gorsuch, Justice Gorsuch is an aficionado of fishing, so we kind of played into that interest of his by serving up bass fishing. Justice Kavanaugh is an avid runner. His favorite shoe is Asics, so we created a connect the dot that plays into that interest of his. Some of the clerks were the trademark imagery that we're appropriating is their college mascot. Some of the clerks, corporate imagery is a place they might have worked. If you look them up on LinkedIn, oh, this clerk worked at, Twitter, this clerk worked at Box.com. So we're hoping that, they'll find some delight from their own personal affinities with the images we put in front of them.
And I take it, well, I'll ask, I get the Winnie the Pooh part for Justice Ketanji Brown Jackson. I think when the drawing is completed, she's holding a Jack Daniels, or Winnie the Pooh is holding a Jack Daniels bottle. What's the thought there?
Well, that's a commentary on Lisa Blatt. She's the lawyer representing Jack Daniels, and in Jack Daniels' brief, Jack Daniels is quite clear in saying, we do not want our whiskey associated with poop. And they don't like a whiskey associated with the dog poop rubber dog toy. So we're associating their whiskey now with a different type of poo, not dog poo, but Winnie the Pooh. So we're hoping that even Lisa Blatt, Jack Daniels' lawyer, when they read our brief and they say, oh, this is actually kind of interesting, why wouldn't we want our whiskey associated with this poo? This is a good poo. This is Winnie the Pooh.
I'm glad I asked.
There you go.
I think certainly one of the last questions. We can see how it goes. Am I interrupting at all, or did you want to?
No. I've got.
At least, and again, I don't teach intellectual property. I don't teach trademark, but my impression was that art did better. That art more or less prevailed over commerce within the confines of the Ninth Circuit decision that's on appeal and going to be argued. That judgment that's going to be argued before the Supreme Court. What do you make of the fact that this was the case where the court granted cert, understanding that, the conventional wisdom of, oh, well, if they were going to affirm, they could just deny cert and leave the judgment intact?
Yeah, no, that's a great question too. We were hoping that our case in the Second Circuit was a couple months further advanced than it was, because our case, to the extent that the court was interested in granting cert in a trademark or art appropriation, we believe our case would have been a more powerful vehicle, given our art bona fides, than the rubber dog toy. But maybe we're wrong about that. Maybe the court grants cert with a rubber dog toy to help us understand that, a rubber dog toy is an expression. There's a joke here, there's a parody here. This is kind of easy. So there's a large part of us that are of the view that the court grants cert in Warhol and the court grants cert especially in Jack Daniels, to reset this clock, to get this pendulum back into the First Amendment corner and away from the corporate property right drift that's happened for the last couple of decades. Because last time the court talked about copyright, as I mentioned, in a creative context, 9-0. But there's been a lot of haze ever since then, and there's a whole bunch more haze in trademark. So we're hoping that you grant cert in Jack Daniels to help the lower courts understand that they've been getting this, many of them, not the Ninth Circuit, but many of them have been getting this wrong. And you can imagine a scenario where cert is granted to create a clear kind of First Amendment reminder to the trademark bar that this is protectable stuff going on here. So you can imagine a scenario where it's 9-0 in favor of VIP and against Jack Daniels. But you could also imagine a scenario, given the world in which we live, where it goes the other way. And I gotta say, as an observer of the Warhol oral argument, I was a bit confounded by the questions that were being lodged and from whom those justices were lodging those questions. There were some justices who you would think would be disposed to say, well, this is clearly fair use, this is simple. And those were utterances not coming from those justices. And there are other justices that you would think, John Roberts, for example, who would not see fair use or would not see permissibility in VIP, saying, as he did, oh, this is art, this is easy. so it was very difficult to read the tea leaves in Warhol. It would be very interesting to see whether we're able to read tea leaves in a week and a half from now. Because our hope, maybe it's a hope beyond hope, that the cert was granted to get this pendulum back where it needs to be.
Yeah, and just from, a mile away, if not further, when we were talking about a half hour ago and you were introducing the two cases, my intuition was, oh, the copyright case, copyright rights will prevail, which was just an intuitive feel based upon there's a real similarity between the images, and especially the way you explained copyright law. And yet at the same time, truly, my instinct was, oh, but the trademark, that's also intuitively, how can this fall on the side of a protectable mark, if you allow that sort of oversimplification? And then the instinct or intuition that I have now is, I sometimes feel that, and I really do think this is a hallmark of the Roberts Court, in jockeying for the middle, in jockeying for the neutrality. We saw this, for example, I think in gerrymandering cases, I believe. Well, we take two cases, the Republicans win one, the Democrats win one. And I really think that, at least, knowing nothing other than what we've talked about, the intuition would be, oh, this will be a split. And if that would be true, in my mind, again, knowing nothing more than what we've talked about, it would go along those lines. But who knows?
Right. No, that's a great observation as well. A couple of reactions against that. I guess if you wanted to take the cynical view, the really cynical view, you get a 9-0 on First Amendment grounds for both of them. And why is that? Well, anytime the court has the ability to expand First Amendment rights for an individual, an Andy Warhol or a MSCHF, that First Amendment broadening applies to the corporate entities as well. And so it provides a mechanism whereby you could invoke First Amendment protections for dark money and political speech, PACs and all that kind of stuff. So that could possibly be an undercurrent here. If there's going to be a split, though, and one of these two battles is in the favor of the corporates and the others in favor of the creatives, I really, maybe this is self-serving, I really hope it lands in favor of the rubber dog toy. Now, why do I say that? Well, the dirty little secret of the Lanham Act is there's no time box to the Lanham Act. So unlike the constitutional right of copyright, unlike the constitutional right of patent, those are time box. You have a monopoly right on copy, you have a monopoly right on patent for a limited temporal duration, as it should be. The innovator needs some time to innovate and create, but the culture needs an opportunity to innovate against that innovation. And so when copyright expires after 9 years or patent after 20 or whatever it is, you're serving both of those interests quite well. Creator has some buffer to innovate, but it's limited. That's not the case in trademark. If you're granted a trademark or if you possess a trademark, that is forever until the end of time. And that's a really dangerous piece of weaponry for a corporate property right holder to wield, because they have the ability to wield it quite perniciously, quite broadly, and of infinite duration. And our culture, free society requires a free culture. By free culture is all Larry Lessig stuff. I'm not talking about like free beers for everybody and free gym shoes for everybody. I'm talking about the freedom to borrow and interact and build upon what comes before us. And given the absence of a time box for Lanham Act rights, the Supreme Court could do lots of damage to our culture if it comes out the wrong way on Jack Daniels. More danger, arguably, than if it comes out the wrong way on Warhol.
Really, I'd like to stop there. I think that's a great ending point, and I will give you an opportunity to, to say anything else you would like here that relevant to our discussion, but I think you just stuck the landing.
There you go, Roger. Well, thank you for inviting me. And an apology if I've been a little too long-winded on some of this. It just gets me so exercised to see how badly this could all turn out for so many folks.
Cool.
But thank you for the opportunity.
Oh, it's been our pleasure, and thank you for your time and thoughts. So that's it for today's podcast. Thank you.
Thank you.